Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss the June 12th, 2025 Supreme Court opinion in the case called A.J.T. versus Osseo Area Schools, case number 24-249. We'll first walk through the syllabus and discuss a couple case implications. Then, we'll compare the opinion to the oral argument. Please note that this summary is read by an automated voice. The question presented in this case is whether the ADA and Rehabilitation Act require children with disabilities to satisfy a uniquely stringent bad faith or gross misjudgment standard when seeking relief for discrimination relating to their education. The court held that school children bringing ADA and Rehabilitation Act claims related to their education are not required to make a heightened showing of bad faith or gross misjudgment, but instead are subject to the same standards that apply in other disability discrimination contexts. The court thus vacated and remanded the case. Chief Justice Roberts delivered the opinion for a unanimous court. Justice Thomas filed a concurring opinion, in which Justice Kavanaugh joined. Justice Sotomayor filed a concurring opinion, in which Justice Jackson joined.
Chief Justice Roberts' unanimous opinion. Multiple federal laws afford protections for children with disabilities in public schools. Three statutory schemes are particularly relevant to this case. Section 504 of the Rehabilitation Act of 1973 provides that no qualified individual with a disability shall be excluded from participation in, denied the benefits of, or subjected to discrimination under any federally funded program solely by reason of her or his disability. Similarly, Title II of the Americans with Disabilities Act, ADA, prohibits qualified individuals with disabilities from being excluded from or denied the benefits of a public entity's services, programs, or activities by reason of disability. While the anti-discrimination guarantees of Section 504 and Title II apply in a variety of contexts, the Individuals with Disabilities Education Act, IDEA, offers federal funds to states in exchange for the commitment to furnish the core guarantee of a free, appropriate public education to children in public schools with certain physical or intellectual disabilities. The centerpiece of the idea is the provision of an individualized educational program, IEP, which spells out a plan to meet all of the educational needs of a child with a qualifying disability. Petitioner A.J.T. is a teenage girl with a rare form of epilepsy that severely limits her physical and cognitive functioning. She suffers from seizures that are so frequent in the mornings that she cannot attend school before noon, though she is alert and able to learn from noon until 6 p.m. For the first few years of her schooling, school officials accommodated A.J.T.'s condition by permitting her to avoid morning activities and instead receive evening instruction. But when A.J.T.'s family moved to Minnesota in 2015, her new school district, Osseo Area Public Schools, Independent District Number 279, denied her parents' repeated requests to include evening instruction in A.J.T.'s IEP. Between 2015 and 2018, A.J.T. received only 4.25 hours of instruction daily compared to the typical 6.5-hour school day for non-disabled students in the district. After even further cuts to A.J.T.'s school day were proposed, her parents filed an IDEA complaint with the Minnesota Department of Education, alleging that the school's refusal to provide after-hours instruction denied A.J.T. a free, appropriate public education. An administrative law judge determined that the school district had violated the IDEA and ordered the school to provide compensatory education and evening instruction. Federal court subsequently affirmed A.J.T.'s IDEA victory. A.J.T. and her parents then sued under the ADA and the Rehabilitation Act, requesting a permanent injunction, reimbursement for certain costs, and compensatory damages. The district court granted summary judgment for the school, and the Eighth Circuit affirmed. In so holding, the Eighth Circuit stated that a school district's failure to provide a reasonable accommodation was not enough to state a prima facie case of discrimination under Monahan v. Nebraska, which requires a plaintiff to prove conduct by school officials rising to the level of bad faith or gross misjudgment. Held, School children bringing ADA and Rehabilitation Act claims related to their education are not required to make a heightened showing of bad faith or gross misjudgment, but instead are subject to the same standards that apply in other disability discrimination contexts. A. Outside the educational services context, courts of appeals permit plaintiffs to establish violations and obtain injunctive relief under the ADA and Rehabilitation Act without proving intent to discriminate. To obtain compensatory damages, courts generally require a showing of intentional discrimination, which most circuits find satisfied by deliberate indifference, a standard requiring only a showing that the defendant disregarded a strong likelihood that the challenged action would violate federally protected rights. Nothing in the text of the applicable substantive protections or remedial provisions of Title II of the ADA or Section 504 of the Rehabilitation Act suggests that claims based on educational services should be subject to a distinct, more demanding analysis. B. Some courts, however, have come to apply a heightened intent standard to ADA and Rehabilitation Act claims in the educational services context. This standard traces back to the bad faith or gross misjudgment rule articulated by the Eighth Circuit in its 1982 decision in Monahan, in which the Eighth Circuit reasoned that to prove discrimination under the Rehabilitation Act in the educational context, a plaintiff must show something more than a mere failure to provide a free, appropriate public education. The court explained a heightened showing of bad faith or gross misjudgment was necessary to harmonize the Rehabilitation Act and the IDEA, and to reflect the proper balance between disabled children's rights, state officials' responsibilities, and courts' competence in technical fields. In Smith v. Robinson, this court similarly tried to harmonize the IDEA's specific guarantee of a free, appropriate public education with the protections of other anti-discrimination laws, ultimately concluding that the IDEA's comprehensive statutory scheme was the exclusive avenue by which a disabled child or his parents could challenge the adequacy of his education. Within 2 years, however, Congress enacted a new provision of the IDEA overturning Smith. That provision, now codified at 20 U.S.C. Section 1415L, provides that nothing in the IDEA shall be construed to restrict or limit the rights, procedures, and remedies available under the ADA, Rehabilitation Act, or other federal laws protecting disabled children's rights. This provision makes clear that the IDEA does not restrict or limit rights or remedies that other federal anti-discrimination statutes independently confer on children with disabilities. The bad faith or gross misjudgment rule derived from Monahan is irreconcilable with the unambiguous directive of Section 1415L in imposing a higher bar for discrimination claims based on educational services as compared to other sorts of disability discrimination claims. The Eighth Circuit effectively read the IDEA to implicitly limit the ability of disabled school children to vindicate their independent ADA and Rehabilitation Act rights, thereby making it more difficult to secure the statutory remedies provided by Congress. C. The school district no longer defends Monahan's asymmetric rule and contends instead that bad faith or gross misjudgment is the correct standard of intent for all ADA and Rehabilitation Act claims, whether in or out of schools. This argument was not resolved below, was not raised in the brief in opposition to certiorari, and is outside the question presented. The court declines the invitation to inject into this case significant issues that have not been fully presented. Vacated and remanded.
Justice Thomas's concurring opinion. I correctly resolve the question presented. I write separately to note that in an appropriate case, I would be willing to consider the additional issues raised by the respondents, collectively the district, at the merits stage. Although those issues were not properly before us in this case, they are important and merit our attention in the future. We granted certiorari to decide whether Title II of the Americans with Disabilities Act and Section 504 of the Rehabilitation Act required disabled school children to satisfy a uniquely stringent standard when seeking relief under those statutes. In other words, we took the case to decide whether Title II and Section 504 permit courts to subject one subset of plaintiffs to a higher legal standard than other plaintiffs, simply because their claims arise in the school context. At the merits stage, both sides agreed that the answer must be no. I agree with the parties, holding that school-related claims are subject to the same legal standards as other claims. At the merits stage, the district asked us to go beyond the question presented. Specifically, it urged us to clarify the particular standards that should apply in Title II and Section 504 litigation. In most courts of appeals, the operative standard for discrimination claims under these statutes turns on the kind of relief sought. To establish a violation or to obtain injunctive relief, the plaintiff need not prove intentional discrimination, but to obtain compensatory damages, courts generally agree that a plaintiff must prove that the defendant was at least deliberately indifferent to federally protected rights. The district challenges the no intent standard, arguing that intent to discriminate should be required to establish a violation or to obtain any kind of relief. It presses its theory on both statutory and constitutional grounds. To start, the district argues that the plain text of the underlying statutes prohibit only intentional discrimination. Section 504 states that individuals with disabilities shall not be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any federally funded program or activity solely by reason of her or his disability. Title II provides that individuals with disabilities shall not, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. The district asserts that this statutory language, which prohibits discrimination on by reason of disability, requires a showing of intent to discriminate before a violation can be established. Relatedly, the district contends that the underlying statutes do not permit one standard for damages and another standard for injunctive relief. Title II incorporates the remedies, procedures, and rights set forth in Section 504. And Section 504, in turn, incorporates the remedies, procedures, and rights set forth in Title VI of the Civil Rights Act. Title VI prohibits only intentional discrimination. This court has held that private individuals thus may not recover compensatory damages under Title VI unless they prove intentional discrimination. The district argues that if the incorporation of Title VI rights and remedies requires intent for an award of damages, it should equally require intent for an award of injunctive relief. I share the district's skepticism that the same statutory language can mean two different things depending on the relief sought. The district also raises a constitutional objection, arguing that the Constitution compels a plaintiff to prove intent to discriminate before a court may find a violation of Title II or Section 504 or award any kind of relief. Here, too, I think the district may have a point. Congress enacted Section 504 pursuant to the so-called spending clause. We have repeatedly characterized spending clause legislation as much in the nature of a contract. In return for federal funds, the recipients agree to comply with federally imposed conditions. Just as a valid contract requires offer and acceptance of its terms, the legitimacy of Congress' power to legislate under the spending power rests on whether the recipient voluntarily and knowingly accepts the terms of the contract. Thus, this court has held that if Congress intends to impose a condition on the grant of federal monies, it must do so unambiguously. But the district argues Section 504 unambiguously covers only intentional discrimination. Nothing in the text conveys Congress's intent to impose liability on schools for unintentional discrimination. The district tells us that a no-intent violation of Title II is even more dubious. As an initial matter, the district observes it is unclear what constitutional authority Congress has to require a public school, by way of an injunction to take an affirmative action such as providing additional instruction to a student. Congress enacted the ADA under its power to enforce the 14th Amendment and to regulate commerce. But the Commerce Clause does not give Congress sweeping power to protect the learning environment in schools. And the 14th Amendment does not require schools to make special accommodations for the disabled. Instead, it prohibits only conduct that lacks a rational basis, such as decisions motivated by a bare desire to harm. The district contends that Title II, which targets state and local governments, cannot be read to compel states to expend state funds to accommodate people with disabilities in accordance with federal standards. After all, the Constitution has never been understood to confer upon Congress the ability to require the states to govern according to Congress instructions. In the district's view, requiring a plaintiff to prove intent to discriminate before finding a violation or awarding an injunction is necessary to mitigate these anti-commandeering concerns. I express no definitive views on the additional issues raised by the district here, and I agree with the court's decision to answer only the question presented today. But in a case where the district's additional issues are properly before us, I would be willing to address them. Whether federal courts are applying the correct legal standard under two widely utilized federal statutes is an issue of national importance, and the district has raised serious arguments that the prevailing standards are incorrect. Of course, this court's resolution of these issues could have significant ramifications for both disability law and discrimination law more generally. That these issues are consequential is all the more reason to wait for a case in which they are squarely before us and we have the benefit of adversarial briefing. Until then, I hope lower courts will carefully consider whether the existing standards comport with the Constitution and the underlying statutory text.
Justice Sotomayor's concurring opinion. I join in full the court's opinion, which holds that ADA and Rehabilitation Act claims regarding educational services are subject to the same standards applied in other disability discrimination contexts. In reaching that conclusion, the court rightly declines to entertain respondents' newly raised argument that bad faith or gross misjudgment is the correct standard for all disability discrimination claims under Title II and Section 504 of those acts. I write separately, however, to highlight a foundational flaw in respondents' theory. Respondents contend that the bad faith or gross misjudgment standard is appropriate because the statutes require a showing of improper purpose or animus. That is incorrect. The statute's text and history, as well as this court's precedent, foreclose any such purpose requirement. Recall that Title II of the ADA provides that no qualified individual with a disability shall, by reason of such disability, be excluded from participation in or be denied the benefits of the services, programs, or activities of a public entity, or be subjected to discrimination by any such entity. The Rehabilitation Act's similarly worded prohibition uses the same by reason of language with the modifier solely. That statutory language contains no reference to improper purpose. To the contrary, the phrase by reason of requires no more than a causal link between the individual's disability and her exclusion from participating in or receiving the benefits of a covered service, program, or activity. That is the ordinary meaning of the phrase by reason of. It is also the reading this court has afforded the statutory phrase on numerous occasions. Persons with disabilities can, of course, lose access to benefits and services by reason of or because of their disabilities, absent any invidious animus or purpose. Stairs may prevent a wheelchair-bound person from accessing a public space. The lack of auxiliary aids may prevent a deaf person from accessing medical treatment at a public hospital. And braille-free ballots may preclude a blind person from voting, all without animus on the part of the city planner, the hospital staff, or the ballot designer. The statute's plain text thus reaches cases involving a failure to accommodate, even where no ill will or animus toward people with disabilities is present. There can be no question, too, that the statutes impose an affirmative obligation on covered entities to provide reasonable accommodations, undercutting any improper purpose requirement. Title II of the ADA defines a qualified individual with a disability to mean an individual who, with reasonable modifications to rules, policies, or practices, the removal of architectural, communication, or transportation barriers, or the provision of auxiliary aids and services, is able to meet the essential eligibility requirements for the receipt of services or participation in programs or activities provided by a public entity. A separate provision also contemplates that a public entity under Title II must provide reasonable accommodations subject to certain exceptions. For its part, Section 504 of the Rehabilitation Act makes clear that accommodations, such as architectural alterations, may be required for the purpose of assuring program accessibility if alternative accommodations are not available. These affirmative obligations underscore that the statutes do not require improper purpose to prove liability. Entities can violate the acts, for instance, by failing to install a wheelchair accessible ramp without any discriminatory animus. The statute's use of the passive voice, no qualified individual with a disability shall, by reason of such disability, be excluded, only reinforces that conclusion. As this court has recognized, Congress's use of the passive voice often indicates a focus on an event that occurs without respect to a specific actor, and therefore without respect to any actor's purpose. If there were any remaining doubt, the history and purpose of the statutes further confirm that Congress never intended to impose an ulterior purpose requirement. As this court recognized in Alexander v. Choate, when Congress enacted the Rehabilitation Act, it perceived discrimination against the handicapped as most often the product not of invidious animus, but rather of thoughtlessness and indifference, of benign neglect. As a result, much of the conduct that Congress sought to alter in passing the Rehabilitation Act would be difficult, if not impossible, to reach, were the act construed to prescribe only conduct fueled by a discriminatory intent. That observation applies with equal force to Title II of the ADA, which Congress modeled on Section 504. Consider one of the paradigmatic applications of these two laws, ensuring the elimination of architectural barriers to provide access for individuals with disabilities. Architectural barriers like stairs are rarely, if ever, erected with the aim or intent of excluding the handicapped. Yet if respondents' novel rule were the law, ADA and Rehabilitation Act claimants would have to show that a building's architect acted with animus toward those with disabilities in sketching out her designs. It is hard to imagine any architectural barrier claim succeeding under such a standard. Indeed, the total universe of viable claims of that nature may well be a null set. Respondents' proposed improper purpose requirement would thus eviscerate the core of both the ADA and Rehabilitation Act, leaving millions of our fellow citizens without the protections Congress intended. In short, there is good reason no court of appeals has adopted respondents' 11th hour argument. Congress was not naive to the insidious nature of disability discrimination when it enacted the ADA and Rehabilitation Act. It understood full well that discrimination against those with disabilities derives principally from apathetic attitudes rather than affirmative animus. The resulting laws reflect that understanding and it is not the judiciary's prerogative to override Congress's policy judgments.
Those were the majority and concurring opinions. As this case plays out, it will have immediate and far-reaching consequences. Here are two possible implications. This unanimous Supreme Court decision has two immediate and far-reaching consequences for students with disabilities and their families. First, the court has eliminated a significant legal roadblock that made it much harder for disabled students to win discrimination cases against their schools. For over 40 years, students like A.J.T. faced what lawyers call a catch-22. While adults with disabilities could win cases by showing their rights were violated, even without proving the defendant acted with malicious intent, students had to meet a much higher standard. They had to prove school officials acted with bad faith or gross misjudgment, which meant showing something close to deliberate wrongdoing. Now, disabled students get the same legal protections as everyone else. This levels the playing field and should make it significantly easier for families to challenge schools that fail to provide reasonable accommodations. Second, while the court resolved this specific question, Justice Thomas's concurrence reveals that much bigger issues are lurking beneath the surface. Thomas signals that he's willing to reconsider the fundamental standards that apply to all disability discrimination cases, not just those involving schools. He questions whether plaintiffs should have to prove intentional discrimination even to get basic accommodations, and he raises serious constitutional concerns about whether Congress has the authority to require states to spend money on disability accommodations without explicit proof of discriminatory intent. If the court takes up these broader questions in a future case, it could dramatically reshape disability law nationwide, potentially making it much harder for anyone, students or adults, to win accommodation cases. That's why Thomas calls this a potential sea change in disability law. All right, let's dive into the oral argument tea leaves. At issue during oral argument involved the petitioner alleging that the respondent fundamentally changed positions. Petitioners allege that for decades, the school district defended the Monahan Standard, a rule requiring disabled students to prove bad faith or gross misjudgment, while other disabled people faced easier standards. Petitioner then pointed out that at oral argument, the respondent changed position and argued that everyone should face the harsh standard. According to petitioner's counsel, this statement was exactly the opposite of what they told you at the cert stage. During oral argument, Justice Gorsuch began reading from the school district's own briefs, showing how they'd repeatedly emphasized schools' unique context. When Blatt tried to deny this, Gorsuch read directly. This unique context courts must balance the Rehabilitation Act and ADA's prohibition on disability discrimination with educators' responsibility for determining appropriate special education services. Chief Justice Roberts was clearly unimpressed by the position switch, writing that the district's new argument was not resolved below, was not raised in the brief in opposition to certiorari, and is outside the question presented. But Justice Thomas's concurrence suggests he was listening to Blatt's substantive arguments, writing that the district has raised serious arguments that the prevailing standards are incorrect, and he'd be willing to consider the additional issues. Justice Sotomayor's concurrence reads like a direct response to Blatt's animus claims, writing that such a requirement would eviscerate the core of both the ADA and Rehabilitation Act. This term, we've seen a trend of litigants and judges delving into questions about whether a party switched their position. A unanimous court thought that's what occurred here. While that position switch didn't alone win the day, it seems like the switch inured against the respondent. On the merits, during oral argument, several justices seemed skeptical of the existing standards themselves. Justice Sotomayor questioned where any of these intent tests come from, saying, "I don't know where the bad faith comes from. I don't know where the gross indifference comes from. I don't know where the deliberate indifference comes from." This skepticism shows up clearly in her concurrence, where she systematically dismantles any requirement for animus or improper purpose. But the majority opinion, written by Chief Justice Roberts, deliberately avoided these broader questions. While Roberts acknowledged that courts generally require deliberate indifference for damages in disability cases, he refused to wade into whether that standard itself was correct. Instead, he focused narrowly on the question presented, whether students should face different standards than other disabled people. The court's answer was a firm no. That's it for today's marathon of episodes. I'll follow up Monday with opinion trends and additional analysis. Thanks for staying with me through the 6 episodes. Remember, if you like the content, please follow, review, and share. Talk to you again soon.